Okay, thanks everyone. We're really excited to be here today. I don't get to present with Robbie that often, so this is kind of a treat for us. We're gonna just kick it off and get going right away because we have a lot to get to in an hour and a half. And so our plan is going to be to hold questions until the end, and hopefully we'll have a little bit of time for questions at the end, but if not, you can chase us down in the hallways afterwards or always give us a call or an email at Appleseed. So with that, we'll get going. Hopefully, most of you here in the home crowd are familiar with the Nebraska Appleseed. But we are a nonprofit, nonpartisan, public interest legal advocacy organization. And our mission is to fight for justice and opportunity for all Nebraskans, so no small feat. We do our work within 4 program areas: child welfare, of course, healthcare access, immigration policy, and then poverty. We do a lot of anti-poverty work around the major public benefits programs. And then we like to say that we use all of the tools in the advocacy toolkit. So we do a lot of work at the legislature on bills, advocating for those. We do a lot of community organizing work. And then we do impact litigation as a last resort when that's necessary to change a policy. We also have what we call the Foster Care Reform Legal Resource Center. And that's an opportunity where we work with attorneys who are GALs or represent parents or foster parents in juvenile court cases. And we're available to provide technical assistance to attorneys in those cases to help them raise systemic issues to create more positive precedents in juvenile court cases. And Robbie has a sign-up sheet. We have a listserv for attorneys. We send a monthly electronic newsletter. If you're not already on that list and you're a GAL or represent parents or foster parents in juvenile court cases, please sign up and give us a call if you have a case that we could be helpful with. So just a quick roadmap for what we're going to be talking about today. I'm going to give a legislative update, and we're going to start with a federal legislative update talking about the Preventing Sex Trafficking and Strengthening Families Act. With a focus on the normalcy side. I know you heard this morning a little bit about the trafficking aspect of that legislation. And then I'm going to give an update on some juvenile justice and child welfare bills that passed the Nebraska legislature this past session. One of the most significant of which was LB 566, and that made some changes to the Nebraska Indian Child Welfare Act. And that's the point at which I'm going to hand the baton over to Robbie, who is our resident expert, to talk about the changes to our Nebraska statute regarding ICWA and also some new federal guidance around ICWA. And then he's going to conclude with a case law update on some opinions that have come down from the Nebraska Court of Appeals and Supreme Court on child welfare and juvenile justice issues. Okay, so with that, an overview of the Federal Strengthening Families Act. It was passed by Congress about a year ago, and some provisions went into effect immediately upon enactment, but most of the provisions and all of the provisions I'm going to be talking about today went into effect within a year of enactment. So that was just about a month ago on September 29th, 2015, and then some provisions are phased in up to 7 years after enactment. But again, all of the provisions that I'm going to be focusing on today are in effect now and have been for about a month. Okay, so then I want to just give kind of an overview of the full Preventing Sex Trafficking and Strengthening Families Act, and then I'm going to drill down again on what I call the normalcy provisions. But the first part of it is really the trafficking provisions, and I'm going to skip over that because I know Stephen Patrick O'Meara did a great job talking with you about those this morning. Subtitle B is where the normalcy provisions are that I'm going to be talking about more, and those include 5 provisions. One is to implement the reasonable and prudent parent standard to allow foster parents the authority, liability protection, and training to allow foster parents to give authority to make decisions to allow the foster children in their care to do those kind of day-to-day extracurricular, cultural, and other activities. Second, to eliminate the permanency objective of Appli, which is another planned permanent living arrangement, or what we call independent living in Nebraska for youth under the age of 16. To involve youth 14 or older in case planning and to provide them with a notice of their rights, and then to require certain discharge documents to children who are aging out of foster care. I'll be going back through those in more depth. Subtitle C creates a National Advisory Committee on Sex Trafficking. And then Title II reauthorizes the Adoption Incentives Program and extends the Family Connections Grant Program. It requires states to reinvest savings that were realized from some federal changes to the Adoption Assistance Program. It preserves subsidy eligibility for successor guardians. This is one that I think doesn't happen that often, but when it does, it's important. It enables guardians, when a guardian dies or becomes incapacitated, it allows a successor guardian to be put into place and continue to receive that guardianship assistance subsidy. And then it requires data collection regarding failed adoptions and guardianships. And then also importantly, in this title, it was a change to require notification of parents of a sibling when a child is removed from parental custody. So hopefully most of you know that the Federal Fostering Connections Act several years ago requires notice to relatives, a certain list of relatives within 30 days of a child's removal from the home. And this includes in the class of people for whom they must receive that notice parents of siblings of a child. So that could be a step-parent, different dad, or an adoptive parent of a sibling. And then the last one there, there's a provision about improving international child support recovery, and I'm not going to go into that because I don't know anything about it, but just so you know it's in there. Okay, in Nebraska, I want to just give you kind of a little status of where we're at with the implementation of this, and there are several things there. In advance of the provisions going into effect on September 29th of 2015, HHS issued a policy memo on the reasonable and prudent parent standard and also on transitional living planning. The department has also issued a proposed regulation to implement the reasonable and prudent parent standard, and that had a hearing a few weeks ago, but has not been finalized quite yet. There's also been a process of a stakeholder group that has come together to make recommendations for how we can kind of maximize this opportunity and implement this fully in Nebraska. So many of you, I hope, had an opportunity to complete a survey to provide some feedback on those recommendations. And then Senator Campbell introduced an interim study, LR 248, to look at the implementation of the SFA in Nebraska. The stakeholder group released a report with those recommendations as part of that interim study. And so that report is available on our website. But I think the thing that I want to mention here is that we've done a lot of work already on the implementation of Nebraska and of the SFA in Nebraska, but it's possible there will be some additional changes going forward. So what I'll be talking about today is kind of the status of the federal law and the implementation in our law and policy in Nebraska currently. And then I put on there there's also a separate trafficking task force, which I know Stephen and Kathy spoke about this morning, in addition to there's kind of the normal stakeholder group and then the trafficking work happening as well. And then importantly, Senator Coulterman introduced a bill, LB 296, that passed this past session, and that was to implement that sibling notice provision that I mentioned. And so that is kind of the one piece of the Strengthening Families Act that has already been a change to our state statute. Again, to be clear that notice applies to parents who have legal custody of a sibling of a child, and then it changes the definition of a sibling to include those who would have been considered a sibling but for a termination of parental right, and those considered a sibling under Nebraska law, which includes a legal or biological sibling. Okay. All right, and so the first one I'm going to talk about is the reasonable prudent parent standard. And this is all about normalcy, and that's a word that I hope most of you are kind of familiar with, but I want to take a moment to just talk about the best that I can, because most of what I'm going to be motoring through just a lot of black letter law, but this is one where I think it's important that everybody has an understanding of what we mean when we say normalcy. And the best way that I can explain it is to try to relay what a speaker shared about normalcy that came in for the interim study hearing, and her name is Jennifer Rodriguez. There's actually a video on Appleseed's Vimeo page. You can actually hear her telling it much better, but she grew up in the California child welfare and juvenile justice systems, and she was very active in an organization very much like Project Everlast in California when California passed their reasonable and prudent parent standard, which happened before the federal law. And then she went on to law school and now is the executive director of the Youth Law Center, and she again testified to the legislature about what normalcy meant to her. And what always sticks with me from that is she said, growing up in the juvenile justice and child welfare system, she learned a lot of things on the street, including how to tongue medication, how to make a group home staff quit their jobs, but she never had many of the important experiences, like she said she never had a family dinner, she never had a sleepover, she never played on a sports team. And we know now that those types of day-to-day activities are really important to kids' social development. And so that's what normalcy is about. She also spoke really well about her own children now and being a parent and how she gave an example of her son being sort of hard on himself and how she's seen him blossom through, I think, a competitive baseball league, and a daughter who was slow to learn to read and has really flourished, getting involved in drama and having the lead in a play where she memorized not only her lines but everyone's lines. And so again, these experiences are really important, and this is about giving foster parents some more authority to make these day-to-day decisions to allow children to have a more normal isn't the best term. I think everyone agrees on that, but to have kind of a more typical experience and to be able to do those important activities. So under this new federal law, states must implement the reasonable and prudent parent standard. And here's the definition, and this is right from the federal law. I'm just going to read it. The term reasonable and prudent parent standard means the standard characterized by the careful and sensible parental decisions that maintain the health, safety, and best interests of a child while at the same time encouraging the emotional and developmental growth of the child that a caregiver shall use when determining whether to allow a child in foster care to participate in extracurricular, enrichment, cultural, and social activities. And then the term age or developmentally appropriate means activities or items that are generally accepted as suitable for children of the same chronological age or level of maturity, or that are determined to be developmentally appropriate for a child based on the development of cognitive, emotional, physical, and behavioral capacities that are typical for an age or age group. And this standard applies under federal law both to foster family homes and child care institutions. So foster family homes, that's easy, that's foster parents. Child care institutions under federal law are essentially our group homes. I think it's an institution that's licensed that I think 25 or fewer children. And the law is also specific that child care institutions, so those group home type settings, must each have on site a designated individual who can make those reasonable and prudent parent decisions. And then states must also certify that caregivers have the skills and knowledge to use the standards, so that's essentially a training requirement. And there's also a requirement that states must implement policies to provide caregivers with appropriate liability protections when exercising the standard. And so currently, in the department's proposed regulation, that includes a statement that the department cannot take a licensing action based solely on conduct that is within the reasonable and prudent parent standard. And we have some other things in statute, including our State Tort Claims Act, but I think we need to, at least for Appleseed, I think we want to kind of take a little bit more research to make sure we have covered what we need to there in terms of liability protections for foster parents as required by federal law. And so then for each of these provisions, I'm going to kind of go through the federal law and then kind of where we're at with existing Nebraska statute and policy, and then I have a kind of a set of questions that I'll power through. So our existing HHS regulations are found in 390 NAC 11, and those, as you can see on that last bullet, those cover a range of activities, including things like allowing foster youth to obtain a driver's license, employment, hunting, some things that the reasonable prudent parent standard applies to and some that it probably doesn't, like consent to certain types of medical treatment. But what's interesting when I looked at this regulation is that for the most part, you can see there on the first bullet, it says the worker will involve at least the parent, foster parent, and child in decision making. And when I first read it, I thought that's exactly how we would want it to be. We would want to make sure that everybody's, we're talking to everybody and that everybody's kind of on board. But you can see that when a caseworker has to talk to the foster parent and the bio parent and the JAL and all parties on some of these day-to-day decisions, and that makes it very difficult to make some of those just day-to-day decisions. Like the example we hear a lot is the youth needing a background check in order to participate in a sleepover. So again, the goal here is just to expedite that and make that process a little more manageable for the foster parents and to allow the children to access those activities. And so, again, the department has a proposed regulation to implement the reasonable and prudent parent standard. They have not amended that 390 NAC 11, and so there's some others in Appleseed's interpretation. I think some other amendments that we'll need to look at in regulation and statute to permit caregivers to use a reasonable and prudent parent standard, and in addition to the liability protections and the training. So there may be some changes coming forward. And then again, for each of these, I have a list of questions, policy and practice considerations, and then questions to ask from the bench. You have in your materials it's called the Normalcy Guide for Court Stakeholders, and all of these questions to ask from the bench are included in that Normalcy Guide. So we hope that the judges out there will ask these questions from the bench, and we hope those of you that are in court will be prepared to answer these questions and that you'll take a look at those. But in the interest of time, I'm not going to go through all these questions. But the one that I did want to mention here is, just as a lawyer, this reasonable prudent parent standard is very exciting. But when you think about what is the balance of rights and authority between a foster parent, biological parents, HHS, the courts, and a child or youth, that is complicated. There is sometimes some gray area there. And this reasonable and prudent parent standard, while it's for a really important end, it shifts that balance even further. And so as we're looking at implementing that, I think it's just really important that our law and policy balances and respects the rights of all those folks involved. Okay, so the next provision that I want to talk about is Appli, and this is the federal term for the permanency objective of another planned permanent living arrangement, and this is what was previously termed long-term foster care under ASFA prior to 1997, and again in Nebraska this is our independent living. And so in other words, having a planned response for children for whom the other permanency objectives like reunification, adoption, and guardianship are not appropriate. And just to give some policy context, the concern here, I think, at the federal level is that Appli had become an easy way out for states. Some states, rather than trying to do the hard work of connecting to relatives and others, states too often relied on residential placements and other terms of congregate care for children. I think there was also a concern that Appli was being used in some cases for young children that we were essentially giving up too soon. And so under the new federal law, states must eliminate the use of Appli for youth under age 16, so it cannot be a permanency objective for youth under age 16 going forward, and youth with a permanency objective of Appli under 16, that permanency objective must be changed. And then at each permanency review for youth who are ages 16 or older, so those that could still have a plan of Appli and those that do have a plan of Appli, there are certain requirements put on both the state agency and the juvenile court. So the state agency must document the intensive ongoing efforts to find a family placement. They must document the steps the agency is taking to ensure that the child's caregiver is following the reasonable and prudent parent standard. They must document the steps the agency is taking to ensure that the child has those regular ongoing opportunities to engage in age and developmentally appropriate activities. And then the court must ask the child about their desired permanency plan, make a finding explaining why, as of the date of the hearing, Appli is the best permanency plan for the child, and provide compelling reasons why it's not in the child's best interest to be placed with a parent, relative, or in a guardianship or adoption. I thought there was one more, but there's not. In Nebraska, again, HHS issued a policy memo on transition living planning, which outlines sort of the documentation that must occur at each age. Our existing Nebraska statute, I didn't realize Appli was in there, but it does state there in 43.13.12, it allows Appli as a permanency objective of last resort, but there's no age requirement. And then, as hopefully you all know, our statute requires transition planning at age 16, but does not specify documentation of efforts for family placement, reasonable prudent parent standard, and age-appropriate activities, and those court findings are not in existing state statutes, so we may need to have some tweaks there as well. In terms of the questions, the one that I wanted to point out here is that, as I said, the court is required to ask the child about their desired permanency plan. And so I think that that implies that kids are in court as much as possible. I know there's been a lot of effort to improve efforts to have kids in court, but this is, I think, a place where we're seeing Congress underscore the importance of that. Okay, youth participation in case planning. The SFA requires that for youth ages 16 or older, that the case plan shall be developed in consultation with the child, and then at the option of the child, at least 2 members of the case planning team who are chosen by the child but are not their caseworker or their foster parent. And then it specifies that at least one of those individuals may be designated as the child's advisor on that reasonable and prudent parent standard and those normalcy activities. The state may reject an individual selected by the child to be a member of their team if the state has good cause to believe that that person would not act in the best interest of the child. And then the federal law also says that the case plan must describe the services needed for the youth to transition to a successful adulthood. And I want to pause here because the federal law struck the language independent living and inserted successful adulthood. And I may be reading into it, but I like to think that this is significant. I'm a lawyer, so any changes like that I think have meaning. And I also think it has meaning just as we've been doing some of this older youth work. Independent living, I think, is meant that we want to see young people transition to adulthood and be self-sufficient. I think that that's kind of what that means, at least in one way. But I think it's important. We want young people to be self-sufficient as adults, but we don't want them to be independent in the sense of alone. We want them to be connected to supportive adults. I also think this change to successful adulthood is important because I think it's a higher bar. I think we want them not only to be self-sufficient, but we want to make sure we're providing services to set them up to be successful. And so I think this is a higher bar, and that it's consistent with some of what we're hearing at the federal level with a focus on well-being in addition to safety and permanency. So I wanted to make a note of that. Okay, in Nebraska, again, there's a policy memo on transition living planning that kind of lays this out. Existing Nebraska statute, again, are just kind of a little bit off here, in part because our current statute tracks the Federal Fostering Connections Act well and did a great job of implementing that. But then the SFA made some changes to the Fostering Connections Act. So for example, the existing state statute requires HHS to develop a transition living plan, but begins at age 16 instead of 14. Also requires the transition plan to be developed in collaboration with the transition team and lists those individuals, but doesn't track perfectly the new federal law. I'm not going to pause on any of these, but they're really good, so I hope that you'll think about them deeply at another time. Okay. Rights notification. This is exciting. This is essentially a Bill of Rights for foster children and youth. The SFA says that beginning at age 14, the state must document in a case plan, along with the youth's signature, that they have been provided a copy of their rights and explain to them in an age-appropriate way. And the list of rights must include at least the right of the child with respect to education, health, visitation, court participation, the right to be provided with their credit report and assistance in repairing any problems, and be provided with a copy of their birth certificate, social security card, health insurance information, medical records, and state ID or driver's license, and then the right to stay safe and avoid exploitation, which is a connection to the trafficking piece of this federal law, I think. In Nebraska, HHS policy now requires youth to be provided with a list of rights, and HHS has developed a list of rights for youth, rights and responsibilities. Our existing Nebraska statute requires youth to get a copy of their credit report, but age 16, not 14, is required by the SFA. So again, we may need to do some tweaks there. And then the one that I wanted just to mention here is that, again, in our work with Project Everlast and youth, I think this is really exciting. We hear from them a lot that they're confused about their case and don't understand their rights. And sometimes we just did some focus groups. We heard a lot that they weren't even sure what type of case they had, whether it was a juvenile justice or child welfare case. And so I think this is going to be really important and helpful. But I think, again, with the lawyer hat on, I think it's an important question: what rights exist for youth? What rights do they have? And what enforcement mechanisms are in place to make sure that those rights have effect? I think that's something that we'll need to as a state, take a look at and do well. Okay, and then finally, the pre-discharge documents. As part of the case review system, agencies must provide youth leaving care at age 18 or older. So in Nebraska, 18, 19, or 21 under bridge to independence who have been in foster care for at least 6 months, the following documents, and you can see the list there. In Nebraska, our policy, I think, now tracks that. Our existing statute requires pre-discharge documents, but it isn't perfectly lined up with the new federal law, so we may need some tweaks there. And then, again, really good policy and practice considerations that I hope you'll look at another time in the interest of time. Okay, so that takes me to the end of the SFA portion. We do have some additional resources on our website. This is ongoing work with the stakeholder group, so if you're interested in more information, there is some on our website, and we invite folks to be a part of that stakeholder group. If you're interested, just let us know. Okay, with that, I'm going to transition over to state legislation. And I'm going to be talking about a handful of juvenile justice bills and a handful of child welfare bills that passed the Nebraska legislature this last session. In your materials on the very back, you have a chart that Appleseed put together with our friends at Voices for Children. And it includes all of the child welfare and juvenile justice bills that both of our organizations were tracking this last session. And so not just bills that passed, but other bills that were introduced and may still be in committee to be revisited this upcoming session. So if there's other bills on there that you have questions about, I'm happy to try to answer those questions. The other caveat that I want to give is that I was asked to cover juvenile justice legislation as well, and our work at Appleseed really focuses more on the child welfare side. And so the bills that I'm talking about on the juvenile justice side, most of them we were not directly involved with, so I'm sort of pinch hitting a little bit here. And so if you have any questions about those, I'm happy to try to answer them or refer you to, there's other people in the room that are good resources on that as well, or our friend Juliet Summers at Voices for Children, but at least hopefully this will be enough to help you issue spot some of those issues. So with that, the first juvenile justice bill that passed that I want to mention is LB 265, and that expands oversight of the foster care review office to juvenile justice cases when youth is placed out of home. It also expands the oversight of the foster care review office to trial home visits, where a child is placed back in their home but remains a state ward under probation supervision for up to 6 months. It also allows FCRO reports to come into evidence without anyone offering them. And then it creates 2 separate data systems. One creates a data warehouse pilot project, which would be an external oversight data warehouse to better track data on kids in out-of-home placement. And the second sets aside a portion of the appropriation in the community-based juvenile services aid program to develop a common data set and evaluation of the effectiveness of programs and use of funds within that program. LB 347 extends the oversight of the Office of Inspector General to probation cases. And if you've been following the news, this sparked some, I think, questions about separation of powers and data sharing within the judicial branch. And so there are now conversations happening about moving juvenile justice out of the judicial branch. And I know we have some probation folks here today, so I don't have any answers on that, but I think we'll all stay tuned, and this is the bill that raised that question of oversight of the Office of Inspector General to the probation cases within the judicial branch. LB 482 is also a big one. It provides measures to deinstitutionalize status offenders and eliminate the indiscriminate shackling of juveniles. So it does 4 things. It emphasizes pre-court community-based efforts, so police can refer families to providers instead of citing them. The county attorney must refer and describe efforts to provide community-based services in the petition, and failure to do so is a defense to adjudication. The bill also requires certain findings before a dispositional order placing a 3B youth out of the home. First, that community-based efforts have been exhausted and that there's a significant risk of harm to the child or the community. And finally, juveniles may not be restrained in court unless a judge finds probable cause in a particular case that shackles are necessary to prevent substantial risk of harm or flight, and that no less restrictive alternatives will suffice for safety. And then LB 500 requires a Medicaid state plan amendment to include payment for multisystemic therapy. That is one that Appleseed was involved with. I understand that state plan amendment has been submitted and is still pending. And then LB 605 suspends rather than cuts Medicaid for incarcerated persons. So Medicaid cannot, folks that are incarcerated are not eligible for Medicaid, but if you suspend rather than cut Medicaid, that can help with the reentry transition back onto Medicaid. And this does include juvenile detention facilities and other temporary detention centers. Okay. Now back into familiar territory of child welfare. LB 15 is the GAL standards bill. I hope most of you are probably familiar with this one. In LB 15, the legislature directed the Supreme Court to provide by court rule standards for GALs in juvenile court. And so the Supreme Court held a comment period and finalized a Supreme Court rule by July 1st as per the legislation. A full copy of that court rule is available on the Judicial Branch website, and I think the Court Improvement website as well. And the GAL court rule closely tracks what was previously the GAL standards. And then LB 15 also amended the statute to be clear the GALs must make every reasonable effort to be familiar with the needs of the juvenile, which shall include consultation with the juvenile, and then added the language in his or her respective placement within 2 weeks of appointments and at least once every 6 months thereafter, unless the court approves of other methods of consultation as provided in subsection 6. And then LB 15 added subsection 6, which states that the GAL shall meet in person with the juvenile unless prohibited or made impracticable by exceptional circumstances. And exceptional circumstances include, but are not limited to, situations including an unreasonable geographic distance. And in that case, the GAL shall attempt to consultation by other reasonable means, which includes but is not limited to telephonic or suitable electronic means if the juvenile is of sufficient age and capacity to participate by such means and there are no other barriers preventing such means of communication. If those are not available, the GAL shall seek direction from the court as to other acceptable means. LB 15 also clarified the GALs must provide a written report at every dispositional review and permanency planning hearing regarding the placement of the juvenile, and it now also to specify in that written report the type and number of contacts with the juvenile and other individuals described in the statute, and other further relevant information on a form that is attached to the court rule. And then as an alternative to the written report, the court may provide a checklist to be presented at each hearing. And then finally, LB 15 added language that GALs may be compensated on a per case rate or a system of multi-case contracts, but regardless, hours and expenses must be submitted to the court for approval and should be itemized with the name of the attorney or attorneys assigned to the case that should be recorded in that bill. So I'm sorry, I just read a lot of statute to you, but I think that that's important, so that those changes there now in court roll. Okay, LB 243 was introduced by Senator Bowles, and that did two things. First, it created a pilot for family finding services in at least 2 service areas of the state, and directed the department to contract with providers to do that and also to conduct an evaluation of that family finding pilot. LB 243 also incorporated a separate bill that was a Bridge to Independence cleanup bill. And the B2I portion of LB 243 does several things. First, it expands eligibility to the Bridge to Independence program not only to young people who were adjudicated 3A, but also the equivalent under tribal law. The Bridge to Independence program, I think, was always intended to include tribal youth, but realized that it's not necessarily 3A under tribal code, it might be something different. And so now it includes young people adjudicated the equivalent under tribal law. I think there are conversations happening about how the Bridge to Independence program can work for tribal youth. It also changed eligibility to include young adults who were guardianshiped at age 16 or older. And so now young people who were guardianship, previously they could receive extended guardianship assistance, their guardian could receive extended guardianship assistance on their behalf. Now young people who are guardianship at age 16 or older have the option either to receive extended guardianship assistance on their behalf, or to enter into the Bridge to Independence program, where they're able to receive that stipend directly and receive more caseworker support and participate in the court and other oversight processes of the Bridge to Independence program. And that was a result of hearing from young people about wanting to receive that stipend directly and wanting more work from their support from those independence coordinators. And so there is some requirements in the statute that HHS advised young people about their options of guardianship youth to participate in either program, but if you're a guardian ad litem working with a young person, it would be helpful to talk with them about those options as well. And then secondly, LB 243 clarified that young adults who meet the eligibility requirements for a Bridge to Independence program are eligible for Medicaid by virtue of their participation in the Bridge to Independence program. Previously, other existing categories of Medicaid covered most young people in Bridge, but not all. And so this is intended to cover those gaps. So if you represent a young person that isn't getting that, isn't on Medicaid in Bridge, please let us know. They should be. LB 243 also established really just the term independence hearing, which is the already existing last court hearing before jurisdiction is terminated under 3A for young people aged 16 or older. And it really is an opportunity for the juvenile court to kind of use this already existing hearing like a capstone hearing to talk about goals for the future, and also to give judges an opportunity to advise the child about their rights under the Bridge to Independence program. The department's also directed to advise them of some of those rights, but it's probably more appropriately placed on the court. It also gives the court an opportunity to ask if the young person would like to have an attorney appointed to represent them. And then LB 243 also made some changes to timelines. It requires the department to begin providing services and support within 15 days after the agreement is signed. The department is required to file the petition with the juvenile court upon the child's 19th birthday or within 10 days thereafter, and to ensure no interruption in the services for young people who go directly into the Bridge to Independence program after aging out. And then the bill also specifies that the young adult may request in the agreement or by other appropriate means the time frame in which they would like to have their permanency review hearing, and then the juvenile court shall seek to accommodate that request as reasonably practicable. And this was also a result of feedback from judges and young people. I think it was assumed originally that the annual permanency hearing might happen a year out, but then there was recognition that for some young people, they may have a more acute issue and want to have that hearing right away. And so let's ask the young people what they would like, and so they can request when that would be most helpful for them, and then recognizing that court dockets are busy, the court will try to schedule that as reasonably practicable. And then finally, there was a change to clarify that B2I cases are confidential. There was a question about that previously. So the statute now states that all pleadings, filings, documents, and reports in B2I cases are confidential, and that B2I proceedings are also confidential unless a young person makes a written waiver or a waiver in court. That waiver can be made in order to allow the proceedings to happen outside the courtroom or for any other reason. Okay. And then I think the last one here is LB 292, and that's a bill regarding the Central Registry that was introduced by Senator Colby Coash of Lincoln. And this, I think, it was a result of some concerns that were identified when Senator Coash did an information request about the children on the Central Registry, and found that there were a number of, in some cases, very young children on the Central Registry. I think some of that may have been in error, but regardless, LB 292 now prohibits the placement of children under age 12 on the Central Registry. And then for children aged 12 to 19 years old, the law now requires a mandatory expungement hearing within 60 days of notice unless waived by the juvenile, their parent or guardian, or their attorney. They are to receive a notice, which includes a waiver form, an explanation of the hearing process, an explanation of the implications of being placed on the Central Registry, and that copy of all those notice materials is also to be provided to the child's attorney of record and parent or guardian, and GAL, obviously, if applicable. And then if the youth remain on the Central Registry after that initial expungement hearing, so essentially if that initial expungement is denied, then the law now requires a second mandatory expungement hearing within 60 days of the youth's 19th birthday. The bill now also prohibits the placement of parents in no-fault cases on the central registry, which I think addresses a long-standing issue, and requires immediate expungement if a court-pending case is dismissed or a 3A case is converted to a no-fault. And the bill also requires the HHS to provide some reports annually as to the number of children and others on the central registry. Okay. And then the last one is LB 296, and that's the sibling notice bill that I already mentioned. With that, we'll just keep motoring through. I'll hand it over to Robbie for the Indian Child Welfare Act.
All right, hi everybody. My name is Robbie McEwen. I know we only have 45 minutes left in the presentation, so stay with me here. It's after lunch, and I promised the only reason that I had cake was so I could relate to everybody in the crowd, because I'm pretty tired right now too. But we're going to talk a little bit about the Indian Child Welfare Act during this presentation today, and then we're going to move on to a case law summary. So first, a little bit of background on the Indian Child Welfare Act. It was passed in 1978 by Congress in response to the disproportionate number of Indian children that were in foster care in the country at that time. When the Supreme Court heard its first ICWA case in 1985, the statistics that they went back and looked at from the legislative history of the act indicated that roughly 1/3 of all American Indian children were in foster care at the time of the passage of the bill. And that is problematic for tribes who are sovereign entities if they want to maintain a population or a stable population. So literally they feared for their survival during the passage or prior to the passage of the Indian Child Welfare Act. We're going to talk a little bit about some of the new BIA guidelines today, but for some of the background, the BIA guidelines are from the Bureau of Indian Affairs. They were first promulgated in 1979, and they filled in some of the gaps of the Indian Child Welfare Act. Some of the things that are not defined within the act are defined within the BIA guidelines. It's important to note that our appellate courts have looked heavily at the BIA guidelines since they have been passed to answer some of those questions. And we're going to talk a little bit about some of those things today too, but this year on February 25th, the federal government, they released new BIA guidelines, which modifies some of the interpretations of the old BIA guidelines, and those are effective immediately. They are effective as of February 25th. They replaced the old BIA guidelines to the extent that there are differences, the new ones govern. And that's also important to note because if history continues to follow the path that it is, our appellate courts will most likely look at those BIA guidelines as pretty persuasive evidence in ICWA cases. So it's going to be really important to follow all of them. So we also have a Nebraska statute. For those of you that are familiar with ICWA cases, we had a statute. It was originally passed in 1985. It almost identically mirrored the federal statute. And then the purpose of that was to make sure that Nebraska was following the federal statute. So there wasn't a whole lot of differences. But we also changed that. Earlier this year, LB 566 passed. And this is a bill that clarifies and modifies some of the things that earlier, the earlier version of the statute left as open questions. So it does a lot of different things, but some of the things that it does do is codify 30 years of existing case law. So it is an attempt to make it a lot easier to practice in these ICWA cases and give step-by-step directions for how to do an ICWA case. And to a large extent, the purpose here in bold is still the same. It does underscore the importance of trying to connect children to their culture and to the tribal culture that they would be eligible for. So why do we need this? Why do we need a new statute in Nebraska? Well, we're horrible at ICWA cases in terms of disproportionality. We vacillate between the second and third worst state in terms of disproportionality in the country. And this is pretty problematic. This is the entire purpose of the federal act, and we are not doing a very good job, or we're not doing a better job. Some of the more recent data indicates that those numbers have dropped a little bit. But Minnesota is the only state that's higher than us in terms of disproportionality. And you can ask folks at the Foster Care Review Office, but the number vacillates on a weekly to monthly basis. Sometimes the percentage is lower, sometimes it's higher. But as of November 2013, there were 328 American Indian children in out-of-home care in Nebraska. That is roughly 9% of Nebraska's foster care population, We have a 1% Native population in the state, so that is a pretty high disproportionate rate of Native kids that are in our foster care system. You can also see that Thurston County, where the Omaha and Winnebago reservations are located, consistently ranks number 1 in the number of out-of-home removals of children in the state. So tribal presence. There are 4 tribes that have government headquarters within the state of Nebraska: the Omaha, the Winnebago, the Santee Sioux, and the Ponca tribe. But for those of you that are familiar with ICWA cases, state boundaries matter very little in ICWA cases. In fact, we have over 200 tribes that are represented within our state that ICWA would apply to by their eligibility for membership in their tribes. So 200 different tribes that are represented from Alaska down to Florida. And then we do have a couple of other tribes that has reservation land extending into the state of Nebraska. We have the Oglala Sioux tribe. Their reservation land extends into Sheridan County, and the Sac and Fox Nation and the Iowa tribes reservation extends into Richardson County. So we're going to talk a little bit about first some of the boring procedural changes for LB 566, and then we're going to get to some of the fun substantive changes. So please try and stay awake through this part. I think it's pretty interesting. But one of the things that has changed by LB 566 is the inquiry requirements within the statute. So the new statute requires a court in every single 3A case to ask at the beginning of the advisement of rights whether anybody in the case believes or has reason to believe that an Indian child is involved in the case. This is intended to identify ICWA cases as early as possible in the proceedings because problems arise when ICWA starts to be noticed in the middle of the proceedings. So identifying ICWA early on in the proceedings is always a really good idea. It also requires the CPS hotline to ask every single caller whether they have reason to believe that an Indian child is involved in the situation in the same attempt to make sure that we're identifying ICWA cases as early as possible throughout the process. The new BIA guidelines also have some similar requirements, requiring that courts ask each party to the case whether they have reasonable belief that an Indian child's involved in the case. It does have some interesting language identifying some of the documents that courts can order DHHS to provide, such as genograms, addresses, and domicile information that can help the court identify whether ICWA is going to apply in the situation. DHHS also has the same responsibility under the BIA guidelines and has to continually ask whether anybody has a reason to believe that an Indian child's involved in the case. And I will just pause here to say that the new BIA guidelines and our state court and our state appellate courts in Avery S have recognized that the ICWA can apply when somebody has the reasonable belief that an Indian child's involved in the case. So this Avery S case, it was pretty clear that there was a reasonable belief that there was an Indian child involved in the case because they had a previous case 2 years before that was an ICWA case. And then the second filed case, they didn't apply the ICWA. So our Supreme Court, or our Court of Appeals, determined that the ICWA should have applied in that situation because we should have known. That's what the BIA guidelines are essentially saying. They list some of the reasons up here for how you can determine whether somebody has reasonable knowledge that an Indian child's involved in the case. It does suggest that the ICWA higher standards of proof and the burden of proof should be applied in those situations, so you don't have to really undo those things at a later time. So a good example that I have been using through these presentations for DHHS, for example, it does apply to any employee or agent of the court or DHHS. So if somebody within the Child Support Enforcement Division of DHHS knows that an Indian child is involved in the case, DHHS is going to be deemed to have knowledge under these new guidelines for CFSs too. So it's going to be really important for different agencies or different silos within the Department of Health and Human Services and the court system are communicating with one another to identify whether a Native family is in a case. We're going to talk a little bit here about the legal representation of tribes. For those of you that have practiced in ICWA cases before or have been involved in them, you probably know that tribes have an absolute federal statutory right to participate in any child custody proceeding with one of their members or one of the children that are eligible to be members in their tribe. In those cases, they are not required to be represented by legal counsel. In fact, our state court in Elias L. determined that our state unauthorized practice of law statutes are preempted by the federal ICWA. And since tribes have a federal right to participate, they don't need lawyers to do so. And our state statute now in LB 566 reflects this. We do not require pro hoc vice fees, and for the non-attorneys in the room, that is where you have to pay fees if you are from another state to come practice in the state of Nebraska. And you do not have to associate with local counsel, something that you also have to do in normal cases when you are practicing outside of your own state. Those types of restrictions have been struck down by courts where this has been litigated, and Colorado is one example where that has happened. All right, the Indian child's tribe. This is how the statute used to read. So the tribes have an absolute right to participate in the case, but who is the tribe? What happens when there are multiple tribes in a case? Under the old statutory scheme, the juvenile or county court was the primary decider in determining whether or who would be the primary tribe. And what the juvenile court was looking at was which tribe has more significant contacts with the child. LB 566 changes this a little bit, and it allows tribes, when there are multiple tribes, to be the primary decider. So if tribes involved in a case come to an agreement, a unanimous agreement, then that tribe is going to be the primary tribe. The statute does make it clear that multiple tribes can participate in various areas throughout the ICWA, such as providing active efforts or potentially in the placement preferences. The thing where it starts to get tricky and where you need one tribe to be the primary tribe is if one tribe is intervening in the case and requesting transfer back to their tribal court system. You can't transfer one case to two courts, so there has to be one, and the tribes get to be the primary decider. And if there is not a unanimous agreement between the tribes, it goes back to the existing standard where the juvenile court or the county court is the primary decider in the case of multiple tribes. The BIA Guidelines, fortunately, they spell out what significant contacts means, which is what the juvenile court should be looking at. It's not something that's ever been described before, so if that case in our state statute happens where tribes can't come to an agreement, it goes back to the juvenile court deciding which tribe is the primary tribe. Here's a list of things that should be considered in making that determination, whether or who should be the primary tribe in the case. Notice. As, again, anybody that works with ICWA cases knows, notice is a big deal. Tribes who have an absolute federal right to participate in these cases need to know that there's a case going on. And so the notice provision of the statute before spells out a little bit about how it's done. And the new provision of this, and you can see here, before I get to the new provision of the statute, notice is important because of a couple provisions, intervention, transfer in a case being the ones that come to mind pretty easily. But this has been recognized, the importance of notice has been recognized by the Supreme Court of the United States and our own Supreme Court. But the new provision doesn't really change a whole bunch. It adds a couple of additional requirements in the notice provision. It makes a couple things clear. It's registered mail that we're using now. It cross-references the federal CFR, Code of Federal Regulations that have always governed notice. The thing that you should note now, we have had appellate case law that has struck down juvenile court actions where notice was insufficient. So the new statute intends to address that by requiring each notice that is filed with the tribe be filed with the court within 3 days of issuance. So the court is going to have a chance to look over that notice now too, and hopefully that reduces the number of cases we have where there was insufficient notice sent. And then the last thing, and we're going to talk more about this in a moment, but ICWA applies in voluntary foster care cases now. And notice is one of the things that does apply in those voluntary foster care situations. So we'll talk about that in a moment. The BIA guidelines also talk a little bit about notice. It's pretty close to our state statute, and there's not a whole lot to add. There are suggestions that the federal guidelines make now, and so if you want to be more helpful and follow some of the federal guidelines to make it easier for tribes to identify if somebody is a member, there are ideas up here. All right, substantive changes. The fun part. Let's talk about best interests of the Indian child. LB 566 defines it. It is a very broad definition. There are essentially two prongs for the definition of best interests of the Indian child. The first is it's in the child's best interest to follow federal and state law. It's a pretty general statement. The second is essentially saying we need to do our best to try to comply with the placement preferences of the ICWA and trying to connect that child to the culture when possible under the circumstances. The BIA guidelines don't really have a whole lot of statements about best interests. There is one statement they do make, though, that I need to note for our people because there's potentially some conflicting Nebraska state case law on this issue. The BIA guidelines do state that it is inappropriate to make an independent best interest determination at the point of determining whether there's good cause to deviate from the placement preferences. Essentially the way, and we'll talk about placement preferences in a second, so this may make more sense then, but essentially it says that in order to deviate from the preferences, best interest is an inappropriate analysis. And we'll talk about how that operates in a second, because best interest is the fundamental bedrock of child welfare cases, does apply in the placement preferences, but not like you may have understood it before. But Neary v. is the case that the Nebraska Appellate Court decided earlier this year, talking about whether there was good cause to deviate, and they did determine there was that interest, or the best interest analysis at the good cause to deviate stage. So there may be some conflicting case law with the new BIA guidelines, and you should be aware of that. LB 566 adds voluntary foster care placements to the list of child custody proceedings in ICWA cases. And this is intended to make the transition of voluntary cases go a little bit more smoothly if they have to go to a traditional response mechanism. So some of the things that have to be done in voluntary foster care placements are active efforts, notice to the tribe. The tribe has the ability to intervene in the case. There's not an actual court case, though, so it is just the ability to participate in the provision of voluntary services. The placement preferences apply, and also the additional procedural assurances for relinquishments and terminations arising out of only voluntary foster care placements. This is not talking about purely private adoptions. This is talking about the situation where a family may be involved in a voluntary foster care case or alternative response, if you want to talk about some of the pilot programs throughout the state. And during that time, the family decides, or the one parent decides that I want to give my child up for adoption, I want to relinquish. There are additional procedural mechanisms that the HHS is required to follow in the statute for reporting to the court what they did in the voluntary foster care case. The BIA guidelines agree. ICWA applies to voluntary proceedings. And it does give some guidance here about how that would happen. The thing to note for our purposes, and I think it is helpful, they did a really nice job with this. The ICWA applies to diversion, differential, or alternative response, or any other program. So it really doesn't matter what we're calling it, because other states call alternative response differential response, or they call it diversion. It doesn't really matter what you're calling it. If you're running a non-court involved case, ICWA has to apply under state code and now under the federal guidelines. So it is important to pay attention to those situations. And again, the purpose is to make sure that it's easier to transition over to a traditional court-involved case when the state's already involved in a family's life. We should not have to pause and restart the case over again when it goes to the court system. Active efforts. This is one of my favorite provisions of the ICWA. And active efforts are designed, they are the higher standard and higher level of services that have to be provided in ICWA cases. It's similar to the reasonable efforts provisions of ASFA, but it is not the same thing. And actually, active efforts came before reasonable efforts, so ICWA beat ASFA to it. But what the statute does is it creates a list of things that are considered active efforts under our state law. So as you are going through an individual case where ICWA is involved, you should be following this list pretty closely. It does a couple of other things too, and I want to stop here to talk about one of those things, but it provides additional provisions to ensure that active efforts are put forth before the court in every single case. So, important to note, DHHS is required to file an active efforts report in every single court hearing where there is an ICWA case involved. And any party seeking to effect the foster care placement or termination, this is some of the old language, to an Indian child under state law shall satisfy to the court that one, this is what the old statute said, you had to provide remedial services and rehabilitative programs to prevent the breakup of the Indian child. Two, this is the new provision we're talking about here, you have the responsibility to show that you have made efforts to unite the parent or Indian custodian with the Indian child. And three, that these efforts have proved unsuccessful. So we're going to pause here for a moment and note that this second bullet up here kind of modifies the application of the US Supreme Court adoptive couple v. baby girl in a sort of small way. So in that case, the court determined that there's two prongs of it, but we're only focusing on active efforts. One prong of that case determined that active efforts were not necessary in that case because there was no family to prevent breaking up. Justice Breyer had a concurring opinion, and it was a 5-4 opinion in the case, so his opinion matters a little bit more. He identified a couple of problematic scenarios where ICWA, under the majority's decision, would not apply, and that concerned him a little bit. Essentially, one of those situations was the application of the standard to a father who was unaware of the birth of a child. Through no fault of his own, was not a part of that child's life. There was no family to break up in that situation, so Justice Breyer pretty narrowly focused the decision of the case through his concurring opinion. This is meant to say, yes, Justice Breyer, Nebraska does not want that litigation in our state, so you have to try and unite the family, but you only have to do so to the extent possible under the circumstances. Active efforts is a list of things that you have to do. But there was a 2009 case, and there's other cases throughout the country that have determined that active efforts are not futile efforts. You don't have to do the impossible in ICWA cases. You have to try your best. And that case is in re interest of Louis S. for anybody that's interested in going to look it up. But if efforts are futile, you have met the definition of active efforts, so you have to prove either that you have done active efforts or that you have tried, and that it's not possible to provide those active efforts under the circumstances in the individual case. And so, going back to our last slide, the unite language, if it is not possible to provide active efforts to a person, i.e. they do not want to be involved in the child's life at all, you have probably met your active efforts requirement in your case. The BIA also lists out a lot of things that constitute active efforts. This is pretty consistent with our state code. There are some additional ideas that you may want to look at in individual cases to try and help protect the Indian family in an ICWA case, but pretty consistent with our state statute. And I want to stop here and talk a little bit about the placement preferences. It is one of the substantively most important provisions of the ICWA, and I want to talk a little bit about how they operate. So in an ICWA case, there are placement preferences that apply in each individual case. And the first thing that you would look at is the first level in placement preferences is extended family. That is the ideal placement under the ICWA. And the way that that operates is the tribe is allowed to define who extended family is. If the tribe does not have a definition, and many of them do not, or many of them have definitions that mirror what we have here in our state code or are very similar, then it goes back to the state code. It reverts. And so our state code says extended family is any person who has reached the age of 18 and who is the Indian child's parent, grandparent, aunt, uncle, clan member, band member, sibling, brother-in-law, sister-in-law, niece, nephew, cousin, or step-parent. So it's pretty broad. It can be a lot of different people. It's important to note it's one of the most common misconceptions about the Indian Child Welfare Act. The definition of extended family does not say anything about an individual being native. You can have an aunt and an uncle on different sides of the family. One is native and one's not native. And they're both within the same level of the placement preferences. So we talked a little bit earlier about the application of best interests in an ICWA case. And in this situation, you are within the levels of the placement preferences. So when you're making a determination about who's better, aunt, uncle, they're both within that same level, what should you look to? Again, probably the bedrock of most child welfare cases, best interests. The new BIA guidelines do not prevent this. Our state code does not prevent this. Again, that's probably what you would be looking to make that sort of determination in an individual case. And so when I say levels, it's easy. I'm a very visual person. It's easy to visualize what we're talking about here when you're looking at the levels. We'll look at the adoptive placement preferences first, but you can see there are levels of placement, and they go in descending priority order now under our state code. And when you get to the end of this, that is when there is a good cause to deviate. We can't find anybody that meets 1, 2, 3, 4. Can't find anybody. So at that point in time, then it is appropriate to use the good cause to deviate analysis. And if you can't find any of these people, that is when the new BIA guidelines conflict with our state case, not when you can find people within this list. And so the important thing to note here for the adoptive placement preferences, our state codes added a new placement preference. It has added non-native people to the list. So in an adoptive placement preference, A non-Indian family committed to enabling the child to have extended family time and participation in the cultural and ceremonial events of the Indian child's tribe or tribes is now a preferred placement under the ICWA. This was not in the old statute. It's something that you should look at in adoption cases or termination cases or foster care cases. And you can see here it was added in within the levels. Essentially, the state code makes a policy call that we would rather have a non-Indian family in a family situation providing foster care to an individual child than an institutional placement. And so, again, the non-Indian person has been added to the list. That is the change to focus on within the placement preferences. Good cause to deviate. Not a whole lot to see here, but this is the analysis that we're talking about now, when you can't find anybody within the list. And this is codifying kind of almost verbatim what the old BIA guidelines say, and this is what our courts have traditionally looked to when you're analyzing good cause to deviate or to go off list or off script. And so not a whole lot to see here. It does add a pretty clear statement, and this is the way that the law has been for a long time, but the burden in showing good cause to deviate is on the person trying to argue that there's good cause to deviate, and that burden is clear and convincing evidence. One of the things our state code does is it also defines qualified expert witness. And it defines it in, again, a pretty boring way. It codified the old BIA guidelines. And you should note that our courts have consistently looked to the old BIA guidelines to determine who is a qualified expert witness time and time and time again since 1979. And here, we have just copied it. So that means a couple of really nice and convenient things for ICWA cases. But we'll talk about that in a second. The other important thing to note is that when there are competing expert witnesses, the court still has the ability to assess the credibility of individual witnesses. These are some of the cases that our courts have used or have analyzed who is a qualified expert witness. And again, the fortunate thing about this is all of this case law still should be good. We are codifying what our court has already been looking at for the last 30 years, but now you do not have to go look at the BIA guidelines or multiple documents. It's all within the language of the bill. Most of those cases were about who is an other professional person, the last order of preference for a qualified expert witness. I have lovingly talked about this person being called Bob. His name is Bob the psychologist. Bob has never been to the reservation. Bob has never talked to a Native person. Bob has really no knowledge about the cultural competency for how tribes operate. That's why he's kind of last on the list. He's the least preferred qualified expert witness. But Bob the psychologist can testify as a qualified expert witness in ICWA cases. And what qualified expert witnesses usually testify about is that there is likely to be serious emotional or physical damage to the child in TPR cases or foster care placement cases. So any psychologist in your community can be a QEW in an ICWA case under our state code. Any single person. In addition, it doesn't actually have to be Bob the psychologist. It can be Bob the very experienced DHHS worker with a law degree who trained people. And I think that's one of the cases we had up there. And many of you in the room know who I'm talking about, but she's no longer with the department anymore. But she was a qualified expert witness. It could be a lot of different people. But he's the least preferred. But the new BIA guidelines, they didn't like Bob the psychologist as much as the old BIA guidelines do. And so you will note one thing here is that the other professional person has to probably has spoken with a Native person before under the new BIA guidelines. He has to have some level of cultural competency. You will also note, if you're paying close attention to the language, that this is a non-exclusive list that the new BIA guidelines have promulgated. These are the individuals that are presumed to meet the QEW standards. So Bob the psychologist, while not explicitly mentioned, may not be prevented by this. It's something to keep watch, though, because all of these guidelines are currently going through the process of being promulgated as fully enforceable federal regulations. And if that happens, we may consider revising our state code. But for right now, it's pretty consistent. Emergency foster care. Quickly, LB 566 really doesn't talk a whole lot about emergency foster care. We do note that ICWA does apply to emergency foster care situations, and that's sort of the extent of it. LB 566 gives a nod to it. The new BIA guidelines really go into detail about how emergency foster care placement should be done to comply with the Indian Child Welfare Act. I urge you to read it. It can be scary at times. There are placement preferences and higher standards that apply in ICWA cases. But if you remove a child from a dangerous home at 2 o'clock in the morning, they are not going to overturn your entire case because you failed to place the child with extended family at 2 or 3 o'clock in the morning. You have to try, and you have to do your best to apply the ICWA as you go along. That's essentially what the new BIA guidelines are saying, so I urge you to read that if you are in the world of handling emergency foster care placements. And that brings us to the end of our ICWA presentation. Some of the things we did not talk about in our slides today because we don't have time, and I think I'm running probably a little bit short on time for the case law summaries. It makes a couple of other changes that you should be aware of. One, the new BIA guidelines expressly get rid of the existing Indian family exception. It was a judicially created doctrine from Kansas in the 1980s. Even Kansas has reversed it, and so it is a dying doctrine, and the BIA guidelines attempt to kill it. One of the other things noted in the new BIA guidelines is that there is no aggravated circumstances exception to the ICWA like there would be in ASFA or the reasonable effort standard. There is Nebraska case law specifically on this issue, and it found the same thing. But it was overturned, and it's sort of an open question within our state court about whether that's the case. It's a really interesting statutory interpretation question. So for those of you that are interested or want to talk to me about statutory interpretation later, I'd love to talk to you about it. It's super interesting, I promise. And then, yeah, believe it, statutory interpretation is the best. Professor Berger at UNL would be very happy if he watches this video back. And then the last thing that the new BIA guidelines do, and really important for a lot of people in this room, it makes clear that ICWA applies in juvenile delinquency proceedings. But that is kind of it. It does not say how that's going to work. It does not tell our states how to fill out the details about how that's going to work if your state hasn't been doing that. So it is really important to note that in foster care situations, when there's a juvenile delinquency case, all of these requirements and more, just general requirements that our new statute did not touch, are going to apply in juvenile delinquency proceedings under the new guidelines. So we should pay attention to that and try our best to make sure that we do it right. All right, on to the case law summary. And if you can't tell, I really like ICWA. We're going to talk about an ICWA case first. This is an ICWA case that Appleseed was involved with. It was in re interest of Shayla H., and it happened at the Court of Appeals and the Supreme Court. I'll be quick here with this, but essentially the facts of the case were the children were removed after allegations of inappropriate abuse by the father's girlfriend. There was a handprint on one of the children's faces. The children were removed from the home. The tribe was notified. The whole ICWA was going to apply. And then there was a determination that it was safe to put the kids back with family. At that point in time, kids went back in home with the family, and the court made a finding, which we thought actually, and our co-counsel in the case thought was a typo, but the county attorney really wanted it to apply in the case. They wanted to try and argue that ICWA did not apply in in-home cases. Because the physical location of the family was in home, you wouldn't have to do things like active efforts or notice or allow the tribe to participate. The Court of Appeals disagreed, and later the Supreme Court did as well. And what they were looking at, a couple of their justifications. One, it would be really problematic for the ICWA not to apply in in-home cases or when the children were not physically present, or when the children were physically present with their parents and not in an out-of-home placement, because things like active efforts, notice, tribe's right to participate, you sort of would flip the light switch off, where ICWA wouldn't apply in those situations. But for those of you that have been involved in foster care cases before, trial reunification does not succeed 100% of the time. It's a pretty fluid system where kids move in and out of a case. And so they determined it didn't make sense to sort of flip different standards on and off throughout the case. Second, they determined that it would have been problematic for those exact reasons when a case does proceed to foster care or termination of parental rights. It would make things difficult, and you may have to start over and may delay cases. Third, the Court of Appeals did throw in an argument that they had tacitly recognized this was already the way that it worked in one of their other cases, and then they also looked at supporting case law from California, Oregon, and Iowa to determine that ICWA does apply in in-home cases. That is the biggest takeaway from this. County attorney sought further review for the U.S. Supreme Court, and cert was denied. Or no, that they sought, not the US Supreme Court, that's a different case. County attorney sought further review from the Court of Appeals to our Nebraska Supreme Court. They did take the case, and then the Supreme Court agreed with our Court of Appeals. The next case, in re interest of Zachary D. and Alexander D. In this case, there were 2 kids that were adjudicated. One was, and there was a subsequent TPR. 1 kid was adopted. 1 kid stayed in foster care. The kid that stayed in foster care had a pretty sad situation. He was in foster care since he was 3 years old. There were multiple behavioral disorders. He went to multiple treatment centers. There were 17 different foster care placements that this child had been in. The juvenile court ordered DHHS eventually to place this child in a place called Envisions in Norfolk. Envisions terminated services to the child, and then the caseworker notified the GAL and county attorney of the new placement. And how am I doing on time? Okay. I'll go really quickly here. Essentially, the issue in this case was the department was held in contempt by the juvenile court for ordering, or for the not informing everybody that the child was going to move. The juvenile court had an order saying the child shall remain in Envisions until further order of the court. They moved the child without a court order. The court held them in contempt. They did 2 things. They gave DHHS the choice to pay $5,000 or to rewrite their internal policies. And those specific to rewriting of internal policies were requiring that the department not be allowed to delete or destroy correspondence when a case is open until 6 months after its closure. And then also they wanted to make sure that there was, or mandate within DHHS's internal policies, immediate contact with the guardian ad litem and other stakeholders when placement is threatened. The Court of Appeals determined that, 1, of course, juvenile courts, and this has been recognized throughout the years, have the ability to hold any party to the case in contempt of court, but they are allowed to make this specific type of contempt finding. 1, because, and the most important thing to look at is not the money issue. There was one argument raised by DHHS there that there wasn't the actual use of the word willful in the order. The Supreme Court said that doesn't matter. They did that orally. It was fine. The interesting thing here is that they have the authority to order DHHS to internally rewrite their policies as a contempt punishment, and it's not a separation of powers issue because internal management of the agency is not akin to a rule or regulation like the department tried to argue pursuant to the Administrative Procedures Act or Section 84-9012. Next case, Cassandra B. In this case, there were 2 kids that were found to be within the meaning of a 3A, and the juvenile court found that the mom had used inappropriate discipline. One of the older siblings had severe mental and behavioral health needs. The issue in this case, ultimately, though, was throughout the pendency of the juvenile court case, mom eventually wanted to homeschool the kids, or wanted the kid that was placed back in home with her. And she was not allowed to because it was determined that it was not in the child's best interest at the time. Mom appealed, arguing that this violated her constitutional right to direct the education of her child. The Supreme Court concluded, yes, 1, this is a final appealable order because this is a substantial right, recognized for about 100 years now in the US Constitution, but this is not within the bundle of rights that parents have when in foster care. When it is not in the child's best interest to be homeschooled, and the juvenile court decides that, the parent does not have the ability or the right anymore to homeschool their child when the juvenile court says it's not in their best interest. Zanea W. In this case, I'll just skip right to it. This is a pretty typical termination case. Nothing really special about the individual facts of the case, except mom had severe mental illness. In this case, the county attorney proceeded under 292 sub 2 and sub 7, which are 2 of the provisions that you can use to terminate parental rights in Nebraska. Mom tried to argue or revive an argument from the 1980s that this violated her due process as somebody that was mentally ill, and that if you were mentally ill, you would only be allowed to proceed under 292 sub 5, not any of the other proceedings that are listed in the code, because doing so would violate her rights, or due process rights. The Supreme Court refused to address the issue. They indicated, this is an older argument, but it was a very split court at the time that this 86 opinion came out. The argument may still be around. They determined that it didn't apply with mom. She did have a guardian ad litem in the case to represent her interests. Just something to pay attention to in the future if you do have a case that involves this situation. The Trenton W case, in this case, there was a 3A case for neglect, and again, we'll skip right to the issue here. The Court of Appeals determined that the juvenile court erred in admitting certain evidence in the case because the petition did not contain any specific factual information. There was no affidavit accompanying the petition to adjudicate. The affidavit included with the motions for temporary custody filed the same day did have an affidavit attached to it, but that was not attached to the petition. So none of that evidence came in the adjudication. Again, one of those lawyer things, but it is really important to staple the right piece of paper to the right piece of paper. So none of that evidence came in the case. The evidence that did come in was through the admissions of Dad, and the only evidence that the court considered on appeal in the record were things that Dad admitted essentially, which were he had gotten drunk one time in front of his children, and that he had left his children alone in a hotel room to be supervised by their 12-year-old child. The Supreme Court, or the Court of Appeals, has a really nice discussion over who is mature enough to babysit, and it is really interesting to read. But they determined that those two facts alone were not sufficient to adjudicate. Essentially, plenty of 12-year-old kids are old enough to babysit. The kids were fine, so with those two facts only being considered, case was dismissed as to Dad. Also an interesting note, and we don't have time to talk about it, Mom failed to perfect her appeal in the case, so they did not consider Mom's arguments, and the adjudication remained in effect to Mom. So it's also really important to make sure that you read your appellate rules of practice. Danergy G, in this case, again, we'll skip right to the issue. The Court of Appeal, or the Supreme Court in this case, Court of Appeals, determined that statutory rape victims that have a child conceived of that statutory rape, if you are convicted of statutory rape, you do not have the ability to parent that child. It is never in that child's best interest to be a parent in that situation because of a statute that was passed that applied specifically to the Parenting Act. There was a really nice analysis of why it would not make sense to apply this standard only in divorce cases and not apply it in juvenile court cases. But when you have a child, the ultimate takeaway is when you have a child that is conceived as the result of a statutory rape, the person that's convicted cannot have any parenting time under the Parenting Act or the Juvenile Code anymore. All right. Time? All right, good. I'll slow it up a little bit down now. So a couple of other cases of note. There's a Justine J case. In this case, the state failed to present sufficient evidence that termination of the mother's parental rights were in the best interest of the kids because the children were already in permanent placements. There was no evidence presented as to how the TPR would be in the children's best interests or would affect their emotional state. And there was no therapist or expert witness testifying at the hearing as to the child's best interests or the children's best interests. Therefore, the Supreme Court determined that the juvenile court did not commit plain error in its refusal to TPR as to Mom. The Seth K case, in this case, the juvenile court had invited the mom to participate in voluntary services. They did not adjudicate the case under 3A. And the mother was never ordered to complete a case plan by the court, and her lack of compliance with a voluntary case did not weigh against the notable progress that she had made after they filed and she was ordered to do things. So the Court of Appeals reversed the juvenile court's termination of parental rights order in this case. And although this case came out after we were required to submit our presentations, there is another really important case that I wanted to just briefly talk about. It's in re interest of Ence. I'm probably pronouncing that wrong. Ennis or Ence J. Came out October 16th. But it has been an open question in Nebraska law for some time whether juvenile courts had the equitable authority to allow foster parents to intervene in foster care cases or 3A cases. The answer to this question is no, they do not. The Supreme Court came out and said foster parents do not have the equitable ability to intervene, and because essentially juvenile courts are courts of limited jurisdiction. They don't sit in equity within the state of Nebraska. And so if you are a foster parent that is trying to actually intervene and not just participate, which is allowed under the state code, you're going to have to make a showing that you are somehow more connected to that child than just being a foster parent, if it's still possible at all. So with that said, that is the end of the presentation, and I'd love to take any questions. Sarah, I know would too. We have a little bit of time. So anybody have any questions from either presentation?
On the sheet of legislation, how do I find out more information on 290, the funds for victims of trafficking?
And the question for those of you watching the video at home, if we're still recording, is how do we find out more information about any of the legislation that Sarah talked about today? If you'd like any more, if anybody would like information about any of the cases or the statutes that we talked about, we would love to, and Mary Ann's bringing out a microphone for those of you that want to ask more questions. We'd be happy to answer any questions that anybody has. Just give us a call, shoot us an email. We can talk about any of the statutes or cases, except maybe the juvenile justice ones, because that is a little bit out of our expertise, but we can refer you to the right person if that's the case. All right. Oh, question.
I just wondered if there have been any tribes that intervened in involuntary cases.
The question is, have there been any tribes that have intervened in voluntary cases? None that I am aware of yet. I know a couple of tribes that are interested. It is still pretty new. The law went into effect September 29th. But it is interesting, I do think, because as our state continues to move along, foster care looks pretty different than it did in 1978 when the ICWA was passed. Voluntary foster care and connecting services to families that need them outside of the court system is the direction our state continues to go. So as the number of out-of-home or the number of non-court involved cases grows in our state, I think it's going to be a pretty exciting opportunity for tribes to get involved early and provide culturally competent services that they have available. No problem. Good question.
If we don't have more questions, thank you very much to Robbie and Sarah for the great information.